Hi guys, let's talk about imputation of income. What is it? So according to Family Code section 4058B and 4320 Family Code sections, the court is establishing income available for child support and spousal support. And imputation comes in, and what is imputation first of all? Imputation is when one spouse, the earning spouse, the other spouse can be also earning spouse, but the spouse that used to earn money voluntarily in bad faith stops working. And then suddenly there is no money to pay child support, spousal support. So when that happens, the spouse who quit working has the burden of proof to show that it was not in bad faith. And there are several factors to consider. So let's say a scenario of where someone was not laid off, when someone decided quitting high-paying job right after the divorce proceedings started and opened a company that is a startup, doesn't make any money. And before that, that spouse was making $100,000, $200,000, sufficient to feed the family. And let's say the other spouse is working or working also, but not as earning as much. So the factors we consider is ability and opportunity. Based on the education level of that spouse, can that spouse who quit working, has the spouse an opportunity to find the job that they used to have? Is the career change in good faith? Is market demand still there for that job? What is the work history? What is the health of that spouse? So all of these factors would come in to determine whether imputation is appropriate. In cases where a spouse hasn't worked for a long time and let's say was taking care of the children, whether he or she, the other spouse would be better off hiring a vocational expert to determine what would it take for the non-working spouse to become self-supporting. And just as a guideline, whenever spouses are going through divorce, parents in this case, and they have a duty to become self-sufficient. So even though they haven't worked for a long time, they are going to be on notice, it's called Gavin notice, by the court to put them to work. And sometimes it could mean applying to jobs, 10 jobs a week, and then provide report cards to the other side and then once a month to the court. Sometimes there is a legitimate reason to not work. So we look at, is quitting job in good faith or in bad faith? If it's in bad faith, then the court has discretion to impute income to the level the spouse used to earn. So basically, the other spouse who quit work would be treated as if they're making the money, although they're not making the money because of all these factors. Quit job in bad faith, opportunity, market availability, education, work history, all of that, the court has the discretion to impute. Now, if we have vocational evaluator, the vocational evaluator could say, well, the spouse has been out of workforce. Right now, the spouse might be able with this particular degree earn $25 per hour, let's say in California, but in 6 months after earning either a special decree about or training or getting more experience, they're able to make up to $60 per hour or $100,000 a year, whatever vocational evaluation comes out to be. And the vocational evaluator will be also determining all these factors: education, work history, health, market demand. All of that is going to be part of vocational evaluation report. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. If you don't agree with vocational evaluation report, and usually the spouse who is paying is the spouse who is on the other side of the spouse who stopped working is going to be asking for vocational evaluation report. But sometimes the spouse who quit working would also want to have their own vocational evaluation report so that in case there is two different imputation scenarios, the two vocational evaluators could be put on the stand to testify about their findings. So, of course, the spouse who quit working would have potentially most likely lower imputed income than the spouse who will say, well, the spouse has PhD and master's and they should be imputed to a higher level based on job opportunities in that area. There are situations when there are disability. If a spouse who quit working claims disability, what I would look into, did the spouse who quit working, did he or she apply for disability? If not, that's another factor for the judge to consider, that potentially they did quit in bad faith. It makes sense sometimes to subpoena their employer to see whether they would release, and usually they would, the HR file to see if there was something going on, performance, or if the spouse was always late, not showing up to work, things like that that led to the spouse to be let go in a way that the spouse quit. Sometimes the discussion is, well, what would you like us to fire you, or will you quit? Or so these type of discussions might not be part of the file, but what could be part of the file is the performance and missing days of work and things like that. If the spouse who is involved in this process is not able to hire a vocational evaluator because of cost involved, vocational evaluator could cost easily $5,000, and the other spouse never earned more than minimum wage, then the spouse who is seeking support from the spouse who is not working could ask the court to impute a non-working spouse with minimum wage. That's another thing I had happen in my case. I was involved in a case where we filed for spousal support, child support. My client was from another country and didn't work throughout the marriage because her husband said, don't worry about it. Just, you don't need to work. And so I will support you. And then as it comes, when the child turned 3, the marriage was 7 years long, she asked for spousal support. And it was a big surprise to me at that time that at the first hearing, the judge imputed my client with minimum wage income right away. And surprise, surprise, within a week she found a minimum wage job. Actually, she found a job that paid her higher than minimum wage. So in a way, silver lining, it was a motivator to find a job. But the point is, yes, the court has discretion to impute minimum wage. I haven't seen ever since a court imputing minimum wage on a first run. Usually the court gives a warning, give her a warning, seek work order, give some time to find an opportunity, and doesn't do it like that. So I have to say this was in San Francisco, a very young judge, not going to call names, and very ambitious judge. Let's put it that way. Now, if the spouse is at the retirement age, then of course the court is not going to impute income. After age of 65, no one is going to push the supporting spouse to work. So if the spouse who decides to retire retires, then their income, whatever that is, for example, if they don't make any W-2 wages income, but they have, for example, Social Security income, they have retirement 401k income, they have investment income, any income that is considered income on tax returns is considered income available for support. Finally, once there is a court order about child support, spousal support, how to enforce it if the other spouse is not paying it? Let's say the court said, okay, I will impute you with minimum wage, you have to pay X amount of dollars. So one way to do it, if they found a job, is to do wage garnishment, but if they don't have a job, to file a contempt action, which is quasi-criminal proceedings, and for each violation, so each month that spouse doesn't pay, it could be up to 2 days in jail. Never seen anyone being put in jail, but it's technically, theoretically, and potentially practically possible. So then the spouse who's not paying will be in the contempt proceeding. The spouse who is also requesting could hire child support services, and child support services would be enforcing it in a way that let's say lawyers would not be able to do it, or they can put a travel stop. I remember there was a case where a spouse didn't pay in arrears over $2,500, and so there was a travel stop, so they couldn't leave country. Don't know if they couldn't leave the state. I don't think that was the case. Don't remember exactly the details of that particular case, but also remember child support services when the spouse who didn't pay sold a home. Child support agency was able to freeze the remaining proceeds in escrow and take it out from the escrow directly, although child support services did not have a lien on the property. So that is something I would say that child support services, I'm now assuming it, I don't know for sure, could also take tax refund money. So if they can reach so far. So if you are on the side of seeking support, those are the tools. If you're on the side of being imputed, then the way to protect yourself is either to find a job to reach the level of imputation, or hire your own vocational evaluation to lower the imputed amount to the level that vocational evaluator would say is appropriate in your case because of the reasons why you are not working at this point. And then if you're disabled, of course, apply for disability right away. I think that's it for imputation of income. I think I covered everything. Click like, subscribe, and I will see you in my next video. Bye!